Hello everyone, welcome to Management 413 Employment Law here at the UAB Ch School of Business. In this video we will be covering employment tests using Chapter 6 in our textbook. Here's the outline of what we will be covering: drug tests, medical examinations, genetic tests, polygraphs, sometimes known as lie detector tests, and tests that are designed to determine ability. Drug testing is a very important category of test, something that an HR professional should be very familiar with the rules of the road for. They can be used prior to hiring. Sometimes they are used in periodic medical exams that might be required. Sometimes they can be used upon reasonable suspicion of drug use, but your policy at your organization should allow for that type of drug testing. And then sometimes there is random drug testing. The best way to test for drugs is often a urine sample, but a surprising number of drugs can be detected in a strand of human hair as well. Generally, an employee may not refuse to be tested. The states have stepped in here and are the primary regulators of drug testing. About half of states have drug testing laws, but no state prohibits all drug testing. All states recognize that, at least in certain circumstances, dangerous businesses, for example, testing will be required. Whether or not there is drug testing would definitely be a subject for collective bargaining, how and whether it was provided if a company were unionized. There is a story that a well-known dairy had an ice cream sandwich line that announced one day that to the employees on that ice cream sandwich manufacturing line, to the employees in there, that there was going to be drug testing the next day, and the next day no one showed up for work. Today, if there was a random drug testing policy, which there might be at a food company like that you want to make sure is super clean, they probably wouldn't have had to have given notice, but that's very much company by company as to how much notice has to be given. For public employers like UAB, for example, the United States Constitution would apply. The Fourth Amendment to the Constitution prohibits unreasonable searches and seizures, and the courts have held that random drug testing is therefore not permissible at public organizations, government organizations. But even public employers may test for drugs where the employees have jobs that might be jeopardized and safety might be jeopardized. Recently, Florida's governor tried to require drug testing for all state employees, and that was struck down. See the textbook page 189 for that. As we'll see in a minute, there is a federal law that requires drug testing for employees in transportation businesses, which is a good thing considering all the trucks on the road. The most common procedures that are required by state laws are that there has to be some kind of notice, that employees must be given a copy of the policy, whatever it is, and that only licensed labs can be used. Employers usually have to confirm the test results if they come back positive, at least. Employees have to be given the test results in writing and an opportunity to explain, and there has to be privacy observed in the whole process. If you are an employee of a transportation company, there are even more rules, as you can see here, including that there has to be a proven chain of custody for the samples that are given so that no one can argue that somebody else's sample actually was the one that was tested. Any organization such as UAB that does business with the federal government has to comply with the Drug-Free Workplace Act. That's been around for about 25 years. That requires that those organizations have policies on drug use, inform the employees about those policies, establish what the penalties are. It doesn't say exactly what the penalties have to be. And if there are any drug convictions, the federal government among your employees, the federal government wants to know, not an arrest, but a conviction. The Americans with Disabilities Act is very important when it comes to drug testing. An employee is considered disabled if he or she has undergone treatment for drug addiction and is no longer using drugs. If there hasn't been any treatment for drug addiction, if there hasn't been a diagnosis of addiction, then the person is not disabled. But once that diagnosis comes in and the drugs are no longer being used, then that person is disabled and cannot be discriminated against and perhaps would have to be offered a reasonable accommodation. So here are some smart practices that you can look at on your own. Stop and pause on each page. They repeat what the case law just provided in the prior slides. Let's remember that most employees are at-will employees, meaning that unless there's some substantive right given in a law somewhere, they can be terminated without cause. And for that reason, courts are generally not willing to step in and protect an employee who has failed a drug test. But if you're not treating employees across different classes of employees the same, you could be subject to a disparate treatment claim. For example, if you're only uh, terminating the African American employees, then that might give rise to a disparate treatment claim under Title VII of the Civil Rights Act of 1964. Medical examinations are another hot topic in HR law. Here's the definition of a medical examination. This definition is important when we are looking at the protections that employees are given under the Americans with Disabilities Act, because the ADA is very clear in saying that you may not require a quote medical exam before making an offer of an employment. You can require one after you've made an offer if the offer is conditioned on getting a medical exam. So often there are disputes over exactly whether something that an employer is asking of an employee that is health related is a medical exam or not. Once somebody has been hired, you can only ask an employee to take a medical exam if it's job related and consistent with business necessity. Here are some examples of tests that are and are not considered medical examinations. An HIV test is considered a medical exam, but a polygraph exam, if it were legal, as we'll see in a minute, they're usually not, would not be a medical exam. An agility test would not be a medical exam. Also not a medical exam would be a drug test that's looking for illegal substances. On the other hand, testing for prescription drugs that might create a disabling condition is a medical exam. So you can see here that you have to really be careful and be knowledgeable about the medical procedures that you're asking of your employees. Take a look at the case in your textbook, Kroll versus White Lake Ambulance Authority, where an employee was required to undergo counseling. And the question was whether or not that is considered a medical examination. If it were, the employer would have had to demonstrate that it was job related and a business necessity. The employee argued that it was a medical exam, and the employer argued that it was not. The protections of the Genetic Information Non-Discrimination Act come up when you are looking at medical exams. That law forbids employers from acquiring genetic information from applicants and employees. So what does that mean for medical exams? It means that if you are able to ask an employee or an applicant to take a medical exam, you can't get genetic information. And that generally means that you cannot ask for a family medical history, because that would reveal genetic information. If you asked, what did your grandparents die from, and you said all four died of cancer, that might indicate a genetic predisposition to Cancer. Polygraphs and honesty test. A polygraph, sometimes known as a lie detector, actually does not detect lies, just measures changes in your breathing and other physiological responses. In any event, they're usually illegal. It used to be, before that federal law was passed, that pre-employment polygraphs were routinely used, and Congress passed a law that said that shouldn't be. There are exceptions in that law. For example, if there's been uh, a theft by employees, then it is permissible to ask employees to take a polygraph exam. It's also legal under certain circumstances to ask applicants and employees to take paper honesty tests that are designed to get them, after they answer a certain number of questions, to reveal whether or not they are honest. This would be particularly the case, for example, with security guards. Another type of test would be a test designed to measure ability of some kind when you are hiring somebody. Intelligence, aptitude, specific job skills, personality traits, strength and physical fitness. And the higher you score, the more likely you are to be hired. Those are legal, but they cannot be administered in a discriminatory way. How might they be discriminatory? Look at this case again involving Target on page 189 of the textbook, where they asked applicants for security guard positions the question to say true or false. Answer the question true or false. I am very strongly attracted to members of my own sex. The court found there that that was discrimination on the basis of gender. When you are looking at tests of ability, you need to be mindful of the risk that you might be discriminating against a protected class. So you ought to be aware of exactly what the overall pool of applicants might be. And this is a pretty important concept. The EEOC would say that when you're using tests that you should use the 4/5 rule. And you can see here what the 4/5 rule is. Stop and pause. You probably have to stare at this for a while. If the selection rate, the percentage rate of applicants in a protected class is less than 80% of the selection rate for the overall uh, labor pool, then it's probably discriminatory against the people in the protected class. This is a rule of thumb. An example of a test might be a cash counting or a math test for bank tellers, and the 4/5 rule might apply there as well. The theory of the 4/5 rule is that statistics don't lie, and it just shouldn't be that someone in a class and someone outside a protected class would have that much difference in their scores on tests unless it was somehow related to the fact that they were in that protected class. So what do you do if you really think you need a scored ability test? You have to, if you're the employer, prove that it was job related and a business necessity. There are several ways to go about this. I'm not going to go into too much detail on those. You can try to show its content was valid. For example, a word processing test for a secretarial job would be the example of a content test. You can also look not at the content, but at the measure of job performance. But you have to demonstrate that there is a statistical association between the performance on the test and the actual performance on the job. In order to do that, you should probably have a validation study done. The EEOC provides guidelines for how to proceed there. Take a look at the case EEOC versus Dial Corporation, where a canned meat manufacturer, Spam, had a test that they used called a work tolerance test that they said was designed to make sure that workers didn't injure themselves on the job and therefore was a business necessity. The EEOC, however, found that it really wasn't a business necessity. It really wasn't safety related. Obviously, tests have to be scored, and cutoff scores for passing or not passing have to be set, and that can create some legal risks. You can't have one passing score for people in a protected class and another passing score for people not in the protected class. Take a look at this case in the textbook involving a transportation system in the city of Philadelphia, where the system required that police officers in the bus and subway system be able to run 1.5 miles in 12 minutes, and said that was a business necessity. And the court had to look at whether or not they agreed with that very stringent requirement. We will have a simulation for a pair of you. Here is Chapter 6, Question 7. The police department with a physical agility test that 71% of the male candidates could pass, but only 13% of the females. The HR professional and the client will simulate the back and forth on that and tell us how they think that comes out. Another way that medical information comes about is when disabled persons are asking to be accommodate. The legal responsibility is for the employer to accommodate someone who demonstrates that he or she is both qualified and disabled. Before hiring, the employer has to know about the disability. If the employer doesn't know, then there's nothing to accommodate. In the application process, you can't use methods of application that would adversely affect someone in a protected class. For example, you can't use phone interviews unless you also make available a phone that can be read by a deaf person. That's it for this set of slides. In our next chapter, we'll be going further into the life cycle of an HR professional, and we will be looking at the legal risks in hiring and promoting.